Hello everybody and welcome to the next in this series of Trinity Talks. Today we're going to be continuing our set of challenging construction clauses webinars, today focusing on matters of delay and delay liquidated damages. My name is Luke Muchmore. I'm a partner at Trinity LLP and I'm going to be joined on today's session by Harvinder Deal, a counsel in our London office. So the session today will be split broadly into two parts. The first part will be to help talk you through what kind of things to look for when you're drafting a delay LD's clause and provisions, and with a little bit of focus on a recent piece of English case law that caused quite a stir in construction law circles, which is the triple point case. The second part of our webinar today will then deal with things to look out for when there are claims by a contractor for extensions of time for delay, and other aspects of how the claims process takes place and is run. So without any further ado, we'll move on to part one, which Harvinder will be taking. I shall flip over to him now.
Thank you, Luke. Just moving on to the main slide. Obviously, the issues surrounding delay liquidated damages is quite a vast area. So, for the purposes of this webinar, we've tried to focus on some of the more key areas and questions and provisions that come up quite regularly in our contract negotiations, and of which are relevant to the stakeholders. So, as this title says, what to look out for in drafting LD provisions. One of the key questions is always how do you actually express delay LD? Now, typically in the contracts that we work on, and those would be, I guess, even if it's FIDIC or not FIDIC or most international kind of standard forms, the approach that's adopted is basically a rate per day. So if the currency was dollars, it would be a number of dollars per day or per week. And that would be the basic metric about how the LDs were measured. But maybe just to all that's turned into the mechanic. I mean, I guess it's probably worth maybe also just touching on what's the rationale for DLDs. They're required for, I guess, legal and commercial certainty. So in the event that there is delay, the pre-agreed liquidated damages formula creates certainty for the parties in terms of what losses are recoverable in the event that construction is delayed or misses a certain date or a certain event. I just mentioned before about the type of rates and how they would work in terms of the per day, a figure per day or per week. But the rates, in terms of the actual quantity, the rates themselves will depend on the type of project and indeed whether or not there's one or several completion dates. So it's very much a case of cutting a cloth in relation to the project itself. We do see, in terms of delay LDs, although we mentioned a very basic rate, they can be also, we see, depending on the type of project and the appetite for risk, they can often be ratcheted, where, for example, a certain level of delay LDs are payable for a certain period of time, and if the delay continues beyond another period, or continues into a further period of delay, then the daily rate can go up or the weekly rate can go up. So that's a mechanic that we do see used quite often. Something else we often see as well are what we refer to loosely as grace periods, where albeit that the contract often says that delay will be payable from a certain point in time. If there are certain circumstances where the employer is minded to allow the contractor a little bit of grace in terms of a delay that's caused for reasons other than the contractor or something that may be the employer's concern, then the delay LDs we often see suspended for what we call a grace period, which are a number of days beyond which, if the project or construction is still not completed, then at the point where the grace period expires and the full level of the delay LDs can be levied. I wouldn't say that's common across all contracts, but you do see it on some where, again, there's maybe an event of delay which it might be neither party's fault, and there's an attempt to try and ease the contractor's pain. I suppose moving to the sort of the bigger question about how do you size LDs and the loss of revenue, I guess there are some sort of high level parameters which need to be taken into account, which are probably along the lines of the size of the project, the complexity of the project, the duration of the construction period. But I guess when it starts to get down into detail is probably what impact does the delay have on the critical path to completion, and what are the actual costs of the delay. Now, if a delay to the project will cause loss of revenues, it causes additional administration costs, standby costs, or other types of costs, perhaps O&M, then those have to be factored into the rate, that the daily rate, the weekly rate that's being calculated, and then I guess the overall value of the LDs as well. I guess if third-party debt financing is involved, then that will be a key concern in terms of, obviously, debt lenders will be expecting a return by a certain date, and if the project isn't completed by a certain date, then there will be lost interest and other financing costs involved, and so then those all have to be calculated in accordance with an agreed formula and then liquidated down to a daily rate and an overall cap. I guess the other things to bear in mind when we talk about sizing LDs and loss of revenue is, obviously, if the project is one where there's an upstream contract upon which the construction contract is predicated, then they'll have to look into that. Typically, in a lot of the work that Trinity do, we often have maybe a power purchase agreement or a concession agreement which sits above the kind of construction contract, and that contract at times will often state that if construction is delayed beyond a certain point, then there are damages payable to the procuring authority. That being the case, then the level of those delay LDs, to the extent that they're caused by the contractor, will also need to be factored into the liquidated figure. I guess other obviously the price and the value. Whenever contractors price for LD, whenever contractors are required to come up with an LD figure in terms of the overall cap or even the daily rate, then there will be a cost, and that will be reflected in the contract price for the contract itself. So inevitably there'll be a bit of a trade-off in terms of the level of losses that needs to be recovered in the event of a delay, and the actual cost that's been factored into the contract price for the contract itself. And I guess probably the last key element there is what I suppose we refer to as market standard, where obviously in any given project you can start with a blank piece of paper and say these are the losses that we are going to factor into the delay LDs. But in certain sectors, market standard caps have started to have appeared, and they do appear, and they can often be a benchmark. It doesn't mean that the parties and stakeholders have to be slavish to that number, but it does give a bit of an idea of where the overall cap and number sits. So it can be useful in agreeing the same with the contractor and trying to get a reasonable price based on the same thing. We talked about the calculation there, but probably one other point to bear in mind, and this is probably one we come across quite often, is in terms of the language. Delay LDs are not penalties, and when we're talking about an English law context, a penalty clause is unenforceable. So it's very important, I think, just to make sure we're clear on the language. But the English courts have made it quite clear that a liquidated damages clause can't be punitive. It has to be proportionate. And the Supreme Court in 2015, they provided a new test. A lot of you were familiar with the old test, where it refers to a liquidated damages clause needing to be a genuine pre-estimate of loss, which was the test that was applied for a long time to ascertain whether an LDs clause is truly an LDs clause or it's punitive. There was a case in 2015 which people may have heard of called Cavendish and Macdessie, and there was a sister case called Parking Eye and Beavis, where the Supreme Court said that the new test, which is replacing the genuine pre-estimate of loss, is whether the clause itself, the liquidated damages clause itself, is a secondary obligation which imposes a detriment which is, and this is the important bit, out of all proportion to the legitimate interest of the innocent party. If that is the case, if it is out of proportion to the legitimate interest of the party, then it will be considered punitive and therefore unenforceable. And if that happens, then the employers instead will just have a right to claim general delay damages. This is something that we've amended our drafting. In the documents that we work on, we've amended the language when we refer to liquidated damages, and particularly in what we informally refer to as the saving language. We've tried to make it clear when we're talking about legitimate interests, and we're trying to use the actual words which say that they're important to the legitimate interests of the parties. And we also tried to make reference to other points that the courts in McDessie were keen to point out, which is that each party has to be a comparable bargaining power, and each side has been fully advised. So there is a change in the language. We do still see contracts using reference to general pre-estimate of loss, but in the contracts that we use and moving forward, we also now try to reflect the language that was proposed in McDessie and the principles proposed in McDessie. I mentioned a few times about the DLD cap, and the question we get asked quite often is, what is a typical cap? And I think the answer is invariably the same, that it depends. And what does it depend on? It depends obviously on the market standard, but the other thing that it does depend on is something that was touched on earlier, which is the price implication of a given cap. So just to use a very random number, if a very big number was used, for example, if the DLDs were capped at, say, 50% of the contract price, then that would have a significant cost in terms of the contractor having to price that in. So that's obviously has to come down. It comes down to a level which is more workable. But I think the other metric which is really important, more than just having the number, is how much time or delay time or time does the cap actually buy the parties. So if, again, using a reference number, if, for example, the delay LD's cap was priced at 10%, then there is a daily rate which actually calculates by which you can calculate the number of days of delay that the contractor has to keep paying LDs for until such time as the 10% cap is actually reached. Now that metric is quite important because that obviously for all parties works out how much time is left after the scheduled date for completion by when the contractor has to complete. So again, that is an important metric that fits in more, which has to fit in obviously with a number that is and works for the parties. But again, the period of delay that's available, the period of time that's available after the scheduled date for completion is a key requirement. Other factors into working out what is a typical cap, I guess partly is what is the technology. For example, in renewables projects, you may see the cap a bit lower. We see it around to the 10% mark, to the 15% mark often. But in perhaps in thermal deals or deals where there are thermal power deals or deals where there's maybe an element of innovative tech, then the cap can potentially be higher because obviously there's a potential unknown element in terms of how a specific technology may respond in a certain environment or in a certain project. And I guess the other value point to take into account is what we mentioned before, is about what happens in relation to upstream contracts. So if certain costs are payable, say under a PPA or a concession agreement upon which the EPC is predicated, then the value of any liquidated damages payable further upstream also needs to be factored into the cap. Just picking on the last two here, the termination event if DLD cap is reached, obviously there has to become a point of no return where when the DLD cap, say it is 10% of the contract price, if LDs are incurred on a daily basis, which means that the cap has been reached, then at that point, in generally all the contracts that we work with, there is a right for the employer to terminate the contract. If that didn't exist, then it would mean the contract can carry on and the contractor is essentially working through the delay with no compensation to the employer. We find invariably on any contract that involves third-party debt financing that will definitely not be allowed to be the case. And I guess we'd say to any employer as well that wouldn't be a positive position to be in. The delay and the cap is essentially at the end of the process. And we will talk about when we touch on triple point about the effect of what happens at that point. Obviously, a cap can actually be increased by mutual agreement. So we quite often see in the contracts that we work on that if a cap is set at, say, 10%, there is a right for the contractor to increase that cap subject to the employer's say so. That will obviously depend on the economics of the situation at the time, if that's viable for the employer, but it is a mechanism that we do see. And then I guess the final question just on LDs generally is how is the payment for delay LD secured? There are a number of, as you can imagine, obviously the delay LDs is in terms of a source of revenue and source of funds that needs to be accessed by the employer in the event of delay. It's very important that those funds are available. So quite often those are secured by way of a bond, an on-demand bond, which ensures that if there ever is a situation of unavailability of the or liquidity issue in terms of the contractor, or an insolvency issue in relation to the contractor, then the employer has the benefit of an on-demand bond from a reputable bank to draw down on. In any deal which generally involves third-party project finance lending, that will always be the case, insofar as that the lenders to such a project will not want to take credit risk on the EPC, on the contractor or the EPC contractor in that situation, and they want to make sure that that's always supported by relevant covenant support. We do see in some cases, perhaps, particularly if we are dealing with a contractor of significant size, perhaps a parent company guarantee from somebody from a company further up in the chain. The choice about whether you go for bonds or PCGs does depend on the potential the balance sheet strength of the parties. A PCG, for example, is slightly less liquid than a bond, but it's not all. If that can often have a pricing impact, insofar as a PCG doesn't really have in relative terms a cost to the contractor, whereas procuring a bond will have a cost, so it feeds into the general economics of the project. And that's a quick run through some of the, appreciate that's quite a high level run through some key issues, but those are the sort of the main heads of discussion we have whenever we're dealing with stakeholders in relation to delay LDs. I think it's probably useful at this point to flick over to the triple point case, because this is a bit of a sort of case law, or when to say case law, or almost like a workshop case in terms of the application of some of the principles that we've discussed. So if you flick to the next slide, look. So triple point, some people may have heard of. I'm sorry, I just lost my screen. The Supreme Court basically handed down judgment in July 2021. And the parties were basically Triple Point Technology and their company, and a counterparty called PTT Public Company. Now, why Triple Point is important is because it's essentially the current authority for considering what happens to delay damages after termination of the contract. And in terms of its principle, is essentially a reminder to us that it's necessary to carefully consider the drafting of an LDs clause in a contract to assess whether it actually allows LDs to survive termination of a construction contract. Now, just a basic run through the facts. So Triple Point related to a commodities trading company called PTT, who were the employer. Now, PTT employed Triple Point, the contractor, to basically replace and develop a new software system under a contract that was governed by English law. Now, the contract envisaged that the contractor will be paid the contract price on the basis of achieving a certain number of milestones, which is quite a common way that a lot of payment provisions in construction contracts are set up. What happened on the ground was that the contractor only completed 2 milestones and then abandoned the site. And as a result of that, the employer inevitably terminated the contract. Now, when the decision went to the High Court, the employer raised a claim for liquidated damages to cover its losses that are arising after termination, resulting from the contractor's delay. Now, these LDs included some of the things that we talked about already. For example, the additional cost of a replacement contractor to attend the site to finish the work that was left uncompleted by Triple Point. Initially, the claim was granted in the employer's favour, but then the contractor appealed this decision and took it to the Court of Appeal. The reason for the contractor's appeal was that it believed that the LD's clause, as it was actually drafted, only applied from the point in time when the work was delayed until the delayed work was actually completed by triple point by the contractor itself and not by a replacement contractor. So the contractor basically said the clause did not apply where the work was never completed by triple point and if it had been picked up by somebody else. So the matter went to the Court of Appeal, and the Court of Appeal agreed that in their opinion, the LD's clause in question did refer to LDs only applying up to the date that triple point had actually completed the works and didn't continue thereafter. Their reasoning was that given the contractor's employment had essentially been terminated before the works were complete, and the LD's clause specifically referred to liquidated damages applying up to the date that triple point completed the works, it was no longer possible for the employer to claim LDs as a result of that termination. So the view was the way the clause had been drafted meant the termination itself had essentially axed the employer's right to claim further LDs from the contractor. So then the matter then went to the Supreme Court, and Supreme Court considered a wide number of issues on appeal, and it looked through a lot of the varying case law over the years on LDs. The Supreme Court essentially allowed the employer's appeal and reverted to the decision that had been reached by the High Court, basically saying that the liquidated damages clause in question applied up to the date of termination, and then after that only general damages were recoverable from that point onwards. So the Supreme Court upheld what is referred to as the orthodox position. But I think the important thing is, and this is, I guess, where the critical takeaway point is that basically it is subject to the drafting in the contract itself. So it did say many times that subject to the terms of the contract, which is a key point that they keep coming back to. So the Supreme Court basically set aside what the Court of Appeal was talking about. But what is this? I guess the bigger point here is what does this really mean for us and for those wanting to use liquidated damages moving forward? Although I guess overall the Supreme Court's decision is welcome news, it is very important to note the Supreme Court confirmed that LDs may still be in play post termination, depending on the contractual language. So in that case, it's still best practice for parties to the contract to carefully consider and not just assume what the position is in respect of entitlement to LDs before they actually terminate the contract. The market has generally sort of welcomed the triple point decision, but it's important to note that the Supreme Court, as we just mentioned, said the orthodox position can be set aside by way of contrary drafting. And then if it is actually the agreed intention of the parties, and we often as a firm work with clients on international construction deals that are project finance, where the stakeholders do often wish to adopt a position whereby LDs for delay are in fact payable by the construction contractor for the entire duration of the delay, irrespective of the date of termination. So I guess the point is there is that for those parties that wish to adopt that position and that the LD survive termination, then sort of carefully drafted express wording is required, and we would definitely warn against any assumption that position exists in a liquidated damages clause. And this is something we continue to advise clients on moving forward. And it's one that we're happy to discuss with anyone who has any queries or questions in relation to an LD's clause that they're preparing. I think that's probably it in terms of the main discussion on LDs and triple points. I think at this point it's probably useful to flip to the second part in terms of extension of time contractor claims, which is obviously something that sits alongside the part one. And in that sense, I'll hand over to you, Luke. Thank you.
Thanks very much, Harv. Yeah, so as Harvinder just said, part two really is intended to continue on from what we were talking about in part one, where we were really looking at the kind of remedies that an employer has for the delay of the contractor. So in part two, we sort of flip that on its head and look a little bit more at what the contractor, what position the contractor's in when it has been delayed and is seeking to be relieved of some of those consequences of the delay and the potential eventually at the end of the construction period to pay those liquidated damages by way of making claims for extensions of time. So with that in mind, a little bit of background to begin with, really. A lot of the approach that construction contracts take towards extensions of time is born out of what is variously referred to as the prevention principle, and a number of listeners may well have heard the phrase time at large. So for a second, let's just look at what that actually means. Broadly speaking, it's a common law principle that says that a party cannot insist on performance if it itself prevents that performance. So more concretely, in a construction law context, an employer cannot insist on the timely performance and the timely completion of a construction project by a contractor if in fact it was the employer that was preventing that performance from happening, which then has the consequence that you may well have heard this catchphrase time at large. And what really does that mean? Well, several key consequences really. What time at large means is that the contractual date for completion, so the target date or the time for completion, whatever name or definition may have been given to it, will fall away. So that simply drops away, and as a matter of contract, the contractor is no longer bound to complete by that certain date. Instead, what happens is time at large replaces that obligation with simply an obligation to complete in a reasonable time. And obviously, in the world of large construction contracts, that's infinitely less certain and more subjective. Clearly, the parties could make arguments either way as to what that reasonable time might be, but for sure, the contract then has lost a huge amount of its certainty if time becomes at large, and that reasonable time obligation is the only thing that survives. But what that then has a consequential effect of doing is that the delay LDs that Harv was just talking about in the first part, the delay LDs will simply fail because they no longer have a date certain upon which they bite. So the key remedy for the delay by the contractor falls away because you no longer have those delay LDs. I should just add, although the liquidated damages disappear, the employer wouldn't lose a right to claim general damages for the delay by the contractor, but obviously a claim by an employer for general damages for delay when the time for completion has simply become this rather more difficult concept of the reasonable time is going to be a great deal more difficult to prove in front of a court or an arbitral tribunal. So clearly the prevention principle and the existence of time becoming at large is potentially very problematic for an employer. So typically what happens is that well-drafted construction contracts set out a series of contractual entitlements to an extension of time based on the risk allocation that is suitable for the project and has been negotiated between the parties. Which leads us then, logically enough, onto looking at what those typical extensions of time might be. Now, the first one we've put down there for you is obviously to talk about variations or change orders in the scope of work. Now, those are generally speaking arrived at by mutual consent. In some cases, they can be instructed by an employer, at which point they would be obliged to provide and give the contractor a reasonable extension of time. But broadly speaking, a lot of variations and change orders are mutually agreed changes to scope, where things like price and time are obviously looked at again by the parties. They reach agreement to either to potentially add an extension of time on to that target date for completion. The next one we've put in the list there for you is force majeure. I know a number of you will have come across this, and certainly in the last few years, force majeure claims for things like COVID, and before that for things like Ebola and some of the other various pandemic and large-scale issues have been in the news for a number of years, and clearly one of the impacts of force majeure is to create delays in the project. And it's not, you won't be surprised to know that force majeure is a pretty typical entitlement for a contractor's extension of time. The third one in the list there is changes in law, so changes in legislation of the host country where the project is being performed. It will be, as we've said in the slides, subject obviously to the definition of change in law, and picking up on what Harvinder said about a lot of our EPC contracts being drafted in the context of large project finance transactions where there's some form of head contract like a PPA or a concession. That change in law will generally flow down conceptually and on a wording basis from the head contract. And from that point of view, you know, it is fair and right and proper that the contractor is entitled to extend the time that it takes to do work if in fact legislation has been changed from underneath him while he was carrying out the work and made, say for instance, customs processes or imports take a huge amount longer because brand new legislation has introduced additional checks and the contractor can't complete in the original time. So that's another instance where extensions of time would be normal. Ground conditions is often a feature of quite heavy negotiation in a lot of our EPC and construction contracts, as I'm sure you can well imagine. Obviously, the extremely robust risk allocation is to push ground risk, almost all ground risk, down to the contractor, you know, so that it is taken within the lump sum price and within the contractually scheduled time for completion, so that it has to deal with whatever it may discover while it is dealing with surface and subsurface conditions. Now, the ability of contractors to take that risk for the price and on, you know, the fixed term of a typical lump sum EPC will depend greatly on the nature of the project, the ability to carry out ground investigations and geotechnical surveys prior to completion of the contract, the quality of those surveys and what they come back with. So it's always been our experience that ground risk and the ability to get extension of time for ground risk is often highly negotiated in any sophisticated EPC or construction contract. And then the final one we've added there, and pretty typical, and you probably won't be surprised to see it, but if the project company or employer is exercising a right to suspend the works that is not based on any form of default by the contractor itself or its subcontractors or anyone for whom it's responsible, then obviously the exercise of that power by the employer or project company should not disadvantage the contractor, who then receives an extension of time for that suspension. What we haven't put on there, but I should add for you, is that what a good construction contract will often also include is not necessarily a right for the contractor, but rather a unilateral right for the employer to grant an extension of time whenever it sees fit, which might seem like initially a strange thing to include in a construction contract. Why would you just unilaterally want to grant the contractor more time? Well, that really goes back to the prevention principle and the time at large issue that I talked about a few minutes ago. The ability, in order to save the delay LD, so in order to avoid the unfortunate consequence of time becoming at large, which is that you lose your delay liquidated damages and you create all this new uncertainty in your remedies, for the employer to recognise that he may have prevented the contractor completing in a manner that might in fact allow the contractor to make a claim for prevention and put time at large. The employer can take that unilateral step, grant an extension of time, which would in its course then save the delay LDs, which would remain available for the employer further down the line if there was a later delay that was for which the contractor itself was culpable. On the next slide, there is just one additional point that we should bring to your attention while talking about rights to extension of time, and we've alluded to it a couple of times so far already, which is really looking at the rights of the contractor within the context of the wider structure of the project, and taking what is often referred to generically as a back-to-back approach. And what we tend to mean by that really is making sure that an employer or a project company who has a number of rights itself at the level above, at the head contract level, to extend the time that it has to construct the particular project or the particular asset, and that on a wording level and a definitional level, that those entitlements are tracked. And what that really does is allow the employer to minimise the risk of a mismatch in the extension of time that it might get at its head contract level, but as against the extension of time that it might have to grant to the contractor at the EPC or construction contract level. So that's one of the first and really key steps to the back-to-back approach. The other aspect of that really is what has become known as equivalent project relief, which is essentially a specific clause dealing with the interaction and the interrelationship of the claims that the contractor has for delay and in the construction contract, and the same set of events and the same delays giving a right to the project company to an extension of time in the head contract above, be that PPA, concession, or otherwise. And what the equivalent project relief clause will typically do is a couple of key things. It will limit the contractor's claim in that where the set of circumstances, the root cause of the delay is the same thing. It will limit the contractor's delay to its part of the extension of time that the project company can obtain at the level above. And related to that, the contractor will have to support the claim that the employer rather makes at the PPA or concession level. But at the same time, what it also does is obliges the project company to pursue that claim and to seek to achieve the best possible extension of time from the authority under, or the off-taker under, a PPA or concession, so that in fact what is passed down to the contractor is essentially the sort of best possible extension of time that can be obtained in the circumstances. And so it's quite a unique situation in which the typically adversarial situation or relationship between the employer and the contractor needs to be a little bit more partnership orientated, so that good quality claim can be made at the PPA or the concession level above, and allow the extension of time to flow down into the EPC or the construction contract as well. So with that in mind, we've also set out a couple of slides really just to talk through some of the common issues that arise in those sorts of contractor claims for extension of time. And we've broken that down really in a few different ways. The first is obviously just to look at whether or not there has been a causal link between a delay that the contractor says it has suffered, or rather to the events being claimed, and whether they have truly caused a delay to the work. And that is obviously not merely a legal analysis, but it's also a factual analysis of the events that have occurred, but also at quite sophisticated level, an analysis of the delay itself and how the events in fact impacted upon the progress the contractor was making, and whether or not they suffered true delay. Now, delay analysis is, certainly to a lot of us lawyers, something of a dark art, and there are really lots and lots of different methodologies for looking at how delay has impacted the progress of a project. It can be looked at prospectively, retrospectively. It can be looked at on a contemporaneous basis. There are obviously lots and lots of sophisticated software tools that can be used in conjunction with records of facts and events on the ground. and those software tools can analyze the delay in a series of different ways. And some of those methodologies have got lots of different names. You come across things like impacted as planned, or time impact analysis, as planned versus as built, and there are a number of others. Anybody who wants to get into the real nitty-gritty of that is welcome to spend some time looking at the Society of Construction Law's Delay and Disruption Protocol, which is an extremely comprehensive document now in its second edition, used by a great number of practitioners in the delay and claims world, or when they are looking at and analysing the impact of delays on projects. So, but certainly too detailed for the purposes of this webinar, at least. So, having looked a little bit at causation, the structure of the claim, the formalities of the claim are also then something that are extremely important, both for a contractor claiming, but also for an employer who is defending an extension of time delay. A key thing to look for in the construction contract itself is whether or not there is a time bar on the claim. So you will often see in contracts, some of the contracts based on the standard form FIDIC wording, for example, will say that the contractor has a certain number of days after it either became aware or should have become aware, i.e. as a matter of sort of objective fact, should the contractor have become aware of the event that gave rise to delay, it needs to submit the claim. And if it does not submit the claim, it loses the right to make the claim. So it is time barred in that sense. That's a really key thing to be looking for right at the outset. Other aspects of the sort of structure or submission that is made and the formalities that are satisfied is really the quality of the submission that the contractor puts forward. Is it doing some of the things we talked about in the first bullet points there? Is it providing suitable delay analysis to show that the facts and events that it complained of have actually caused a delay? Is it providing a suitable level of detail? And this is where construction contracts can be sometimes quite difficult really to apply to true fact. So you'll often see drafting that requires the contractor to make a sufficiently detailed or a fully detailed claim. Now that obviously I think can be subject to interpretation by both parties, and for many contractors, they're not in the business, if they can help it, of setting out extremely lengthy submissions. They'd like very much to be able to limit their submission to as brief a set of details as possible, claim an amount of time with as little supporting documentation as possible, hopefully have it accepted and generally just move on. And obviously the flip side, is true for the employer. They will want to make sure that they are pushing the contractor to submit good quality submission to genuinely show that delay was incurred, the events caused the actual delay, and that the number of days being claimed can be supported by the information being provided. Which really leads me then on just to emphasize something I mentioned on the previous slide, which is that obviously the kind of equivalent project relief that you will often see in a project financed EPC, then in practice becomes quite difficult, because obviously you're going to, as an employer or a project, you're going to be using that contractor information while you're making your claim for delay up the chain into the head contract. And clearly, the worse the quality of information that you receive from the contractor, the more difficult it is for you as a project company to make a compelling or convincing claim against your off-taker or your authority under your head contract. So it really does play into the quality of the submission, and the formalities that need to be satisfied really does play into so many aspects of a sophisticated project financing. We've got a second slide also, really just to continue talking about some of these contractor claim issues. A lot of what will happen on sophisticated or complex projects are issues of what frequently gets referred to as concurrent delay. So broadly speaking, we're talking about two overlapping causes of delay to the project, one of which entitled the contractor to get an extension of time, and the other cause was a risk that the contractor had to take within the price and the time constraints of the EPC contract. Now, there's been a great deal of analysis, case law, academic writing about concurrent delay, and in many ways it can be misunderstood. Essentially what it's been accepted now as meaning is that true concurrent delay is two or more effective causes of delay having approximately equal causative potency, and they must happen at the same time. So the two events essentially must be taking place at exactly the same time in order for the concurrency to happen. And so as a result, really, based on kind of the factual and delay analysis that I talked about earlier, real true concurrency is rare, and that factual and delay analysis is absolutely key, because often what it does is drive a conclusion that in fact there really is only one true cause of the delay, and despite the arguments being made about two different causes happening at the same time, and in fact there's a concurrent delay, by the time that the parties have got their experts and looked at the facts and carried out their delay analysis, oftentimes there will actually only just be one cause of delay at the end of that analysis having been taken out. Nonetheless, certainly as a matter of English law, this has been looked at a number of times, and broadly speaking, the leading case, which is a case called Malmaison, has settled on what English law considers to be the approach towards true concurrent delay, which is where there are two different causes of delay, one of which entitles the contractor to an extension of time and the other wouldn't. The contractor gets their extension of time, but they are not granted any additional cost for that delay. And that's been settled law now for a number of years. For any of the academics out there, English law diverges from Scots law in this matter. So any Scots lawyers out there can look at a case called City Inn, which took a different approach, which sought to allocate a certain level of contribution from the two different delays in order to come to a conclusion. But City Inn and the Scots approach is not good law for an English law construction contract. The other case that we wanted to mention there at the end, which is relevant to kind of concurrency and competing causes of delay, is a moderately recent case in English law called North Midland and Sidon, where the courts recognised that the parties are entitled, notwithstanding the Malmaison approach, to agree in their contract explicit wording which allocates the risk of concurrent delay as between them. So the parties are free, as a matter of contract, to address the matter of concurrent delay within their contract and say it either does or it doesn't entitle a contractor to an extension of time in X or Y circumstances. And it's worth noting that, for example, that the most recent redraft of the FIDIC suite of construction contracts, so that's the 2017 editions, have actually envisaged that the parties may wish to add something into their particular conditions, their special conditions that sit alongside the FIDIC general conditions, a specific risk allocation as regards concurrent delay. So certainly there are important standard forms in the construction marketplace also seeking to steer parties towards finding an agreement during the negotiation phase on what the treatment of concurrent delay might be. So that really kind of brings us to the end of the things that we wanted to talk about in terms of how you structure delay LDs, the things that you look for when writing delay LD clauses, the impact that the triple point case has had on certainly English law governed construction contracts, of which there are obviously a number in the projects that we do, and then looking at some of the things that are pertinent when contractors make claims in delay scenarios, seeking extensions of time, and employers, project companies try to defend themselves against those contractor claims for extensions of time. We've had a question that we'll try to deal with now. It asks generally sort of how does this relate to COVID claims that have been coming in over the last couple of years, and that's obviously extremely relevant to a lot of people. I think what we'd say to that question really is everything we've described in principle is still completely relevant to a sort of COVID related claim. One of the key things to look for in a kind of COVID related claim by a contractor is obviously, you know, where is the entitlement in the contract that responds to COVID. Oftentimes the first place and the most obvious place to look really is somewhere in the force majeure provisions, and to make a case that the arrival of COVID, the problems that COVID caused, the government shutdowns that happened during a number of the lockdowns in 2020 and 2021 satisfy the requirements of force majeure, and that's really the minutiae of force majeure clauses we know we could do in a whole other webinar, and they would be the subject of a whole other half an hour, 45 minutes to talk about, but that would kind of be the first place you go to. But nonetheless, a contractor making a claim would still have to do all of the things that we sought to describe. So when they make their claim, they need to show that there was a causal link between the pandemic or the shutdowns that were described and the delays that they suffered. They need to be able to show the delay analysis that justifies the number of days of extension that they're looking for, and obviously in a complex project finance structure, are there head contracts, concession contracts, where an equivalent claim can be made by the project company up the chain against a government or an off-taker for that same set of facts. And so will the project company need to use some of that information that the project company, the contractor rather, is putting forward in order to justify its COVID related delay claim. So hope that's kind of given a little bit of insight into how some of what we said today interacts with some of the COVID based claims that will have been made over the past couple of 2.5 years from now. Harv, were there any further questions that came in?
Yeah, there was one that came in while we were speaking, basically centering on if LDs are set aside, whether it's a punitive, then what remedies for delay does an employer have in that situation? I think we maybe touched on this a little bit earlier, but maybe just to expand on it. The remedies that situation would be a claim for general damages by the employer, which means, as in common with any other breach of contract, it would require the employer to first of all establish there was a breach, and then evidence the losses that are flowing as a result of that breach. And there are a number of other requirements, at least under English law, that have to be satisfied before a claim was met. I think the important thing to note there is that well, a couple of things. Well, is that obviously there is a remedy, but it's not on the same status as an LD's clause. And the whole premise of an LD's clause is that once the event has happened, in other words, once the completion has passed a certain scheduled date, then as I say, a liquidated figure, a rate is payable at that point. In the situation where there's a general damages claim, then there's a whole new process that has to be followed at that point, which obviously can be done, but it quite often isn't the intention, at least of the employer, for that system to be in place, which is, I guess, why we re-emphasize the importance of drafting an LD's clause in such a way so as to ensure that it achieves the commercial arrangements of the parties. Quite often we see, and we include this in a lot of the contracts that we work on, a language which tries to make clear that if there is a delay damages claim in the event, for example, a LD's clause is set aside, then we often get the drafting to try and link the level of general damages that are payable link it to the amount of the cap that was originally in place for the liquidated damages. So if, for example, if the LDs clause before it was set aside said that the LDs, the maximum LDs that can be claimed by the employer is 10%, then we often use what we sort of colloquially refer to as saving language to say that, yes, a general claim for damages can still be made, but that will be, in terms of keeping a bit of equity between trying to maintain the original position, is that will be capped at the level of LDs that were originally set. I think one of the things we hear quite often that from stakeholders is that there's an assumption that automatically applies, and that isn't the case. In fact, there's a recent English court decision called Eco World, where it suggested that the level of general damage recoverable will be capped at the level of the unenforceable liquidated damages, but it is very much subject to the drafting. So in the sense that if that language isn't there, then it's not a given that that will definitely be the case. So winding back around to the same point, it's very important to ensure that your LDs clause actually does what you want it to do, as opposed to what you may think it does. So, and again, we obviously advise quite broadly on that, and I hope that's answered that question.
Great, thanks, Al. I think that was really interesting to add at the end there. Well, look, I think that probably brings us to the end of today's session, today's Trinity Talks. We'd like to thank everybody for watching and taking the time to listen. We hope you found it useful. Obviously, please do not hesitate to get in touch with any of your existing Trinity contracts, or email us on the general info email address if you do have any questions about anything that we've raised in this session today, or anything else relating to construction contracts. We will be back soon, hopefully, to focus on another aspect of some of the construction contract work that we do in another edition of our Challenging Construction Clauses run of webinars. So thank you again for your time, and goodbye.
Thank you. Goodbye.